In our scoping paper on offences against the person, we examine the problems with the present law, explore the history of previous reform attempts before discussing solutions that could be taken forward in a full-scale reform exercise. This scoping paper lays a substantial foundation for a clear modern statute, providing a coherent scheme of structured offences that can be readily understood and efficiently prosecuted. The law under which violent offences are prosecuted today is based largely on a statute from 1861. The language of that Act is obscure and sometimes inaccurate. It refers to archaic terms that are no longer of any legal relevance. The Act also includes numerous offences that serve no purpose in modern society. While it's important that we have an offence to deal with assault, we do not need separate offences to deal with assaults on those preserving shipwrecks. Perhaps more importantly, the Act fails to provide a structured hierarchy of offences with accessible definitions of core terms. Reform has been proposed by various bodies on numerous previous occasions over the last 35 years. In 2011, the Ministry of Justice requested us to look again by conducting a scoping study. In doing so in this paper, we ask how a new statute, based largely on the proposals from 1998, might improve things. In particular, we ask about the merits of creating an offence of minor injury which could be tried only in the magistrates' court. That is in response to the evidence that between 7 and 12% of cases of low-level injury are tried in the Crown Court and yet receive sentences that could have been imposed in the magistrates' court. We want to ensure that cases are tried in the most appropriate court given their gravity and complexity. We explore other possible reform options, including whether there should be a dedicated offence to tackle domestic violence. We also ask whether future reform needs to deal with serious harm caused by infectious diseases. That could be by codifying the current law and resolving some uncertainties within it, or in some other way. It is essential that the laws in this area can work effectively in the 21st century, and this scoping paper offers consultees an opportunity to comment on how the law can best be reformed to achieve that goal. The scoping paper is available on our website. Responses are invited by the 11th of February 2015, and we aim to produce a scoping report later that year.